Good day everyone, my name is Bendecio and together with my partner Charlotte Quiñonez, we will discuss the week 13 which is continuation of topic of consent and another topic that is about object of contracts. This module will help you to know for the contract to be valid, the object of the contract must be possible, lawful, and determinate. And to find out what are the exceptions that cannot be the object of the contract, it is important that we are familiar with what the object of contract is, which we will discuss in this module. For our topic overview, we will discuss the following articles. Under continuation of topic of consent, there is Article 1338, Article 1339, Article 1340, Article 1341, Article 1342, Article 1343, and Article 1344, and last is Article 1345 to 1346. Under Section 2 of Object of Contracts, there is Article 1347 to 1348, and last is Article 1349. Let's continue our topic about consent. Under Article 1338, there is fraud when through insidious words or machinations of one of the contracting parties, the other is induced to enter into a contract which, without them, he would not have agreed to. This article means that there is a fraud if one party uses deceitful or tricky words to manipulate the other party. Also, if the other party has directly caused the other party to give consent that without them, the other party would have not entered the contract. In other words, if a person is misled or deceived into signing a contract due to false representations or dishonesty, they have the right to ask the court to annul the contract. Let's have an example. For example, Anna is looking to buy a second-hand car. Ben, a car dealer, shows her a vehicle and claims that it is in excellent condition and has never been involved in any car accident. He even presents a clean-looking inspection report. Relying on Ben's statement, Anna agrees to buy the car for $500,000. A few weeks later, Anna brings the car to a mechanic for routine maintenance, only to find out that the car had actually been in major accident and its engine and chassis were fully repaired. She also discovered that the inspection report was faked by Ben to hide the car's true conditions. In this case, Ben used deceitful words and false informations to convince Anna to buy the car. If it weren't for those lies that Ben said, Anna would not have agreed to the contract. Therefore, under Article 1338, Anna can file for annulment of the contract and possibly claim damages for the fraud committed. Next is meaning of casual fraud. This means that casual fraud refers to a type of intentional deception caused by one party before or at the time of forming the contract to induce the party to give their consent. For example, a landlord tells a potential tenant that the apartment has no pest problems, knowing there is a serious cockroach infestation. The tenant signed the lease based on the false links. This is casual fraud because the landlord liked to get the tenant to agree to the contract. If it weren't for those lies, the tenant would not have agreed to form a contract. How casual fraud committed. Casual fraud committed if the one party used insidious words or it concealed the important information to the other party, otherwise it would not give it consent. As our example earlier, a landlord tells a potential tenant that the apartment has no pest problems. But the landlord concealed the information that there is a serious cockroach infestation. If the tenant knows that there is a cockroach infestation in the apartment, he would not agree or give its consent. Next bullet is if the fraud did not have effect of casual fraud, that is, it did not by itself alone cause the other contracting party to give his consent. It gives rise only to an action for damages. This means that fraud did not cause the other party to give its consent on its own, but the contracting party would have still entered the contract. The contract remains valid, but the injured party can sue for damages. To understand better, here is our flowchart. Is there a false statement or deception? Yes. Did the false statement directly cause the party to enter the contract? If it is yes, serious casual fraud, the contract is voidable and can be annulled plus damage claims. If it is no, the casual or incidental fraud, the contract is valid and the damages can be claimed only. Next is requisites of casual fraud. Not all forms of fraud can dictate consent. In order that fraud may annul consent, the following requisite must be presented. Number 1. There must be misinterpretations or concealment of material fact with knowledge of its falsity. For example, S offered to sell B a ring, claiming that the stone on the ring is diamond. S knows that it is not diamond but ordinary glass. If B buys the ring relying on the truth of the representations of S, the sale may be annulled on the ground of the fraud. Second, it must be serious. Third, it must have been employed by only of the contracting parties. Fraud committed by a third person does not dictate consent unless it was practiced in connivance with or without or at least with the knowledge of the favored contracting parties. For example, a small coffee shop owner wants to buy a second-hand machine for espresso from the supplier. The supplier's friends, not part of the business, tells the coffee shop owner, "This machine is brand new, barely used, but in truth it was 5 years old." If the supplier didn't know that his friend lied, the fraud was by a third person. The sale remains valid. But if the supplier knew or encouraged his friend to say those lies, then the fraud is imputable to the supplier. The contract can be annulled because the coffee shop owner's consent was obtained through deceit. Fourth, it must be made in bad faith or with intent to deceive the other contracting party, who had no knowledge of fraud. Fifth, it must have induced the consent of the other contracting party. And last is it must be alleged and proved by clear and convincing evidence. Article 1339. This Article 1339 is about fraud. It's not just about lying, but also to failure to disclose facts where there is a duty to reveal them. It applies especially when the parties are bound by confidential relationships, like business partners. The contract is voidable and the innocent party can annul the contract and claim for damages. For example, Leo and Marco are business partners. Leo knows that the property they're investing is in under foreclosure, but he intentionally hides it. Marco signs the contract without knowing the truth. In this scenario, Leo remained silent even though he had the duty to disclose to Marco about the risks due to their trusting relationships. Fraud by concealment. This fraud is committed not by lying, but by keeping silent about something that should have been revealed, especially if that hidden fact would affect the other party decisions. In this case, concealment is equivalent to misinterpretations or false representations. Whether the failure to disclose is intentional or unintentional, the injured party can rescind or annul the contract as long as there is a duty to reveal them. Also, the party is misled or deceived in entering into the contract. If the failure is unintentional, the contract is annulled not by fraud, but by mistake or error. If it is intentional, the annulment is based on fraud. If there is no duty to disclose, and the party intentionally keeps silent, the contract remains valid. Next is Article 1340. This article is about the exaggeration of merchants, or in other words, is sales talks. It's not themselves fraudulent when the buyer or the other party has an opportunity to check the product or to know the facts. For example, according to the salesman, this is the phone is the fastest on earth. Nothing else compares. But the customer, she or he has an opportunity to confirm if this is the fastest phone on the earth. Usual exaggeration in trade. It is natural to happen that merchants use exaggerations in their attempt to make sale at the highest price. It is not fraudulent if the customer or person has freedom or opportunity to check or verify the usual exaggerations of merchants. The law gives considerable latitude to seller talks or dealer talks. The law views its statement as a part of a normal selling and not as a binding promises. That's why customer or people should not take such talk literally. It is risky to rely on its truths. Customers should expect to rely on their own independent judgment and to take care of their own concern. In effect, the law does not consider such exaggeration as amounting to fraud that will affect the validity of contract even if it is known as a false by the party making them. To constitute fraud, the misinterpretation should be based on facts, present, and past, or not just on mere expressions of opinion. Next is Article 1341. This article means that mere opinion does not signify fraud. For example, I think this is a good deal. This is not fraud because it's not based on fact but a mere opinion. It is considered fraud if it is from expert that the other party relies on the former special knowledge. For example, Carlos is a licensed real estate appraiser. He tells Lisa this land is guaranteed to rise in value next year. Trust me, I'm an expert. Lisa buys the land based on Carlos' advice. It turns out that the land is in a flood-prone area, which Carlo knew but did not disclose. This scenario, it is fraud because he claims he is an expert, and Lisa relies on his professional opinion. The opinion is misleading. Expression of opinion. To constitute fraud, the misinterpretation must refer to facts, not opinions. Ordinarily, a mere expression of an opinion does not signify fraud. In order that it may amount to fraud, the following requisite must be presented. Number 1, it was made by an expert. Second, the other contracting party has relied on the expert opinion. And third, the opinion turned out to be false or erroneous.
In Article 1342, what being said there is when someone not directly involved in a contract does not invalidate the consent of the parties, unless the misrepresentation leads to a significant and shared misunderstanding between them. So, this article is also known as fraud by a third person. Fraud by a third person have a general rule and the exception. In the general rule, a third person, which is someone who is not a party to the contract, has no legal connection with the contract. Therefore, if that person commits fraud or misrepresentation, it normally does not affect the validity of the contract between the contracting parties. For example, if C, a stranger, lies to A about B's financial capacity, but A still enters into a contract with B, the fraud of C does not violate A's consent. For the exception, if the misrepresentation by the third person causes a substantial mistake that is mutual, it affects both parties to the contract, then the contract may be annulled. In this case, annulment is not really due to fraud, but on the ground of mistake. For example, A and B enter into a contract of sale of land. C, a third person, falsely tells both A and B that the land is classified as residential when in fact it is agricultural. Since both A and B relied on this misrepresentation, their consent is violated by mutual mistake, and the contract may be annulled. Article 1343, which is also known as effects of misrepresentation made in good faith. It is where misrepresentation, which is not intentional, it is a person making the false statement believed to be true, as it is considered a mistake or error. For example, A sells a parcel of land to B, telling him it is a 500 square meter because the tax declaration relied on said so. In reality, the land is only 350 square meter. A acted in good faith, she believed it to be true, so it's not fraud. But since the seize of the land is an essential fact, B may annul the contract due to mistake. In Article 1344, it states that fraud to annul a contract it must be serious and must not have been committed by both parties. Fraud affects a contract in two possible ways. It can make the contract voidable, or it can only give rise to damages, depending on whether the fraud is casual or incidental. There are two frauds in the making of contract, which is the casual fraud and the incidental fraud. In casual fraud is fraud that is so serious it directly causes a party to consent to the contract. Contract is voidable, may also lead to damages. For example, a seller tells a buyer that a parcel of land is free from any mortgage, when in fact that it is already heavily mortgaged. The buyer, believing this, agrees to purchase. The fraud is serious because it induces the buyer's consent. The contract is voidable. While in this incidental fraud, it is a fraud that it is not the main reason for giving consent. Contract is still valid, but the guilty party is liable for damages. For example, a real estate agent claims a house has the best view in the city, when in fact the view is just ordinary. Since the buyer purchased mainly for the location and not the view, the fraud is only incidental. Contract is valid, but the damage may be claimed. There are requisites of casual fraud. First one, it should be serious. Then second one, it should not have been employed by both contracting parties. They should not be in paradelectu, as it states by Article 1411 and 1414. So what does it mean by paradelectu? It is refers to a situation where guilty of fraud, illegality, or bad faith in a contract, because both are at fault. Neither party can go to court to annul the contract or recover what they have given, since the law will not help someone who also acted wrongly. The last one, it should not have been known by the other contracting party. In Article 1345 and 1346, it's about a simulation of a contract. Simulation means pretending. The parties makes a contract looks real on paper, but it's either does not exist at all or hides their true agreement. It is an act of deception done deliberately, usually to mislead persons. There are kinds of simulations: the absolute simulation and relative simulation. In absolute simulations, the contract is entirely fictitious. The parties do not intend to be bound at all. Void from beginning, it produces no legal effect. For example, a father makes a fake deed of sale transferring land to his son, but no money is paid and both know it's just to shield the property from creditors. The second simulation is the relative simulation. It's the contract appears different from the real agreement between the parties. The real agreement is binding as long as it is, does not harm the third person, and it's contrary to law, morals, good customs, public order, or public policy. The contract in relative simulations hides the truth with a real agreement finds. For example, a seller and buyer signs a deed of sale showing 2 million pesos as the price, but in truth, they agreed on 1,500,000. The real price governs is low.
Let's move forward to our next topic, Section 2, Object of Contracts. Under Article 1347, this article is about things that may be an object of a contract, like things that are anything within the commerce of men, can be owned, transferred, or appropriated. Future things like crops to be harvested, and transferable rights like the right to collect debt or lease rights. Exceptions that cannot be the object of a contract are anything outside the commerce of men, intransmissible rights, and future inheritance unless expressly allowed by law. All service as an object of contract is allowed if it is not contrary to law, morals, good customs, public order, or public policy. For example, a shoe factory contracts a supplier to deliver leather next month. It is valid under Article 1347 since future goods may be the object of a contract. A businessman contracts to sell his future inheritance from his father. It is invalid under Article 1347 since future inheritance cannot be the object of a contract. Next article is 1348. This article means that for a contract to be valid, the object must be possible, lawful, and determinate. If the obligation is physically impossible, like delivering the sun, or legally impossible, like selling the government-owned property that cannot be sold, the contract is void. In other words, you cannot make a valid contract out of something that cannot be possibly be done. For example, a company contracts to supply fresh air packed in cans from the moon. The contract is void because the object is impossible. Concept of object of a contract. The object of a contract is its subject matter. This means that in reality, the object of every contract is the obligation created. But since a contract cannot exist without an obligation, it may be said that the thing, service, and right, which is the object of obligation, is also the object of the contract. For example, in a sale of goods, the object is the goods being sold. In a lease contracts, the object is the use or enjoyment of the property. In a service contracts, the object is the service to be rendered. Kinds of object of contract. Object certain is the second essential element of a valid contract. The object may be things, as in sale, rights, as in assignment of credit, services, as in agency. Requisites of things as object of contract. In order that things may be the object of a contract, the following requisite must be present. The thing must be within the commerce of men, that is, it can legally be the subject of commercial transaction. For example, business A enters into a contract with business B to sell 50 office chairs for 100,000. The object is office chairs, which is tangible goods, and also it is within the commerce of men. And because of that, the contract is valid. Second, it must not be impossible, legally or physically. For example, a construction firm signs a contract to build a casino on ancestral land protected by law. But it is legally prohibited use of protected land. The contract is void because the object is legally impossible, which is to build a casino on ancestral land. Third, it must be existent or capable of coming into existence. For example, a farmer sells his rice harvest to be produced next season. The crops don't exist yet, but it will in the next season. The object is valid and has potential existence. Last is it must be determined or determinable without the need of new contract between the parties. For example, a buyer agrees to purchase Lot 12, Block 7 of a subdivision located in Barangay San Jose, Tagaytay, as described in the subdivision plan of file. There is a specific lot of end locations. The reference document is available. That's why the contract is valid, and the land is clearly identified or determinable. Requisite of service as object. In order that services may be the object of a contract, the following requisite must occur. Number 1. The service must be within the commerce of men. For example, ABC Events Corporation enters into a contract with XYZ Catering to provide catering services for a corporate event with 100 guests. The service, which is the food catering, is lawful, commercially available, and commonly contracted. As a result, the object, or which is the service, is within the commerce of men. That's why the contract is valid. Second, it must not be impossible, physically or legally. Jane, a licensed architect, contracts with build corporations to create a design plan for a 3-story residential house. And this is a physically and legally possible because Build Tech Corporation can design a plan for a 3-story residential house to Jane. As a result, the contract is valid. Third, it must be determinate or capable of being made determinate. For example, Mark, a freelance video editor, signs a contract to edit 10 promotional videos, each 2 minutes long with specified deadlines and styles. The service is clearly defined, number of videos, durations, and type of work. That's why, as a result, the service is determinate and the contract is valid. Rights as object of contract. As a general rule, all rights may be the object of a contract. The exceptions are when they are intransmissible by their nature, or by stipulation, or by provisions on law. Examples. Number 1. Outside the commerce of men. For example, is like claims of public ownership such as sidewalks, public places, bridges, streets, or things that are common to everybody such as air, sunlight, and rain, etc. Second, impossible physically or legally. like prohibited drugs and all illicit objects to kill a person, to get soil from Jupiter, or to conduct a building in just one day. Determinable things, all the canvas of rice in the bodega, all the eggs in basket, may land with smallest area. Fourth, future things or rights. Things to be manufactured, raised, or acquired after the perfections of the contract, such as wine that a vineyard is expected to produce, wool that should thereafter grow upon a ship, rice to be harvested next harvesting, and milk the cow may yield, and eggs that hens may lay, and young animals not yet in existence. And last is fifth, intransmissible rights. Political rights such as the right to vote, family, marital, and perinatal rights. Right to public office or to run a public office.
For future inheritance, it is in any property or right not yet in existence or not yet determinable at the time of the contract, which a person may inherit in the future. At this stage, the person has only an expectancy or a hope or chance to inherit, not an actual right. It means inheritance ceases to be future when the decedent or the person from whom the inheritance comes dies, because at that point rights over the state already exist. Here we have the validity of contracts upon future inheritance, the general rule, and we also have the exceptions. For the general rule, it says the contracts over future inheritance are void. Reason is you cannot sell, assign, or dispose of something that does not yet exist or is not yet owned. For example, A tells her friend B, I will sell you the land that I will inherit from my father once he dies. This contract is void because A's father is still alive, so the property is only an expectancy, not yet hers. In the exceptions, we have the donations by reason of marriage. It was said, or it was stated in Article 84 in the Family Code, that future spouses can donate future property, but it will only take effect upon death. Example, before marriage, C donates to his future wife B whatever property I may inherit from my parents effective upon my death. This is valid as a donation factor, not just subject to the limits of law on succession. The other exemption is the partition of property entered by the owner. Its person may partition his estate during his lifetime, but it will take effect upon his death. For example, one, while he is still alive, makes a partition of his estate. Upon my death, Lot A shall go to my eldest, Lot B go to my middle child, and Lot C to my youngest. This partition is valid and will bind the heirs after one's death. For the kinds of impossibility, what does it mean by impossibility? It refers to situations where an obligation or contract cannot be carried out because the performance is not feasible, either by nature, circumstances, or law. The impossibility may be physical or relative. It's a physical. It is happens when the performance of the obligation is not possible in fact, in nature or circumstances. It's either because the thing or service cannot exist or cannot be done. We have here in the physical is the absolute. When nobody can perform the act, no matter the circumstances. For example, flying like a bird and creating a square circle. The contract is void because performance is inherently impossible. The other from the physical is the relative, which the act cannot be done only under certain conditions or because of the personal limitations of the obligor. Example, paying money to a dead person, driving on a flooded highway, or painting a portrait by a blind person. If the impossibility is temporary, the obligation may not just be suspended. If it is permanent, the obligation is extinguished. So for the another impossibility, which is the legal, when the thing or service is contrary to law. This happens when the act to be performed is contrary to law, morals, good customs, public order, or public policy. Even if physically possible, the law prohibits it. The legal impossibility is not possible in law, or it is prohibited or invalid. For example, selling illegal drugs, it is forbidden by law. Donating real property without a public instrument, it's invalid under civil law. So the contract is void from the beginning since it comes an unlawful or prohibited act. For Article 1349, this article means that the kind of object must always be definite, but the quantity can be left open at the start, as long as it can later be figured out from the original agreement without making a new contract. Quantity of object of contract need not to be determinate, is what also known as the Article 1314 was said earlier, which means that what being says in here that when parties enter into a contract, the object must be clear as to what kind it is, like sugar, rice, a car, vegetables, fruits. But the exact quantity of how many kilos, how many pieces, how many liters does not need to be fixed immediately. The contract is still valid as long as the quantity can be determined later based on what the parties have already agreed, without the need to make a new or separate agreement. For example, um, X sold to Y all the meat in their store. Here, the object itself, which is the meat, is determinate, but the quantity, though not yet determined, can be ascertained without the necessity of entering into a new contract. We shall review some of our takeaways that we just tackled, and also that we should know. Firstly is there is fraud if one party uses insidious words or machinations to manipulate the other party. The other party can ask the court to annul the contract if he or she is misled or deceived into signing the contract due to false misrepresentation or dishonesty. Then, failure to disclose the facts when there is a duty to reveal them and a confidential relationship binds the party constituent fraud. Next is exaggeration in sales talk or dealer's talk when there is an opportunity to check the facts is not fraudulent. Expression of opinion does not signify fraud because it is not based on facts but just a mere expression. The objects of a contract is like all things that are anything that is within the commerce of men, future things and transferable rights. In contracts, what truly matters is the informed and voluntary consent of the parties. Lies from the outsiders usually don't matter unless both parties are misled into a big mistake. One can make contracts fragile if it's serious and one-sided. It destroys consent if minor. It just makes the guilty party liable for damages. What matters is the real intention of the parties. Fake contracts vanish in law, but hidden true agreements can still be enforced if lawful. The law does not enforce the impossible, whether by nature or by law. And lastly, inheritance rights are only will after death. Before that, they are just expectation, not property. AI is very useful to us. Let me share with you some of how AI become helpful to us and how we encounter challenges and how we overcome. AI is a big help in completing the task of ours. Since not all written in the book are we able to understand. There's a complicated articles that we couldn't understand well, and especially it's a great help by generating initial ideas and suggesting improvements in grammar. It also provides us quick references and examples that made our work faster and more organized. Mostly, the challenges that we encountered was the authenticity of the context being given. There's so many content that will be given to us when we use AI that doesn't match. Sometimes the generated content was too broad or repetitive. That requires us to give lot of adjustments. We overcome this challenge by reviewing and refining AI-generated drafts together with my co-partner, adding our own insights and cross-checking for accuracy and relevance. This collaborative process ensured our final output and aligned with our goals and make it well polished.
So let's now move forward for our Q&A session. We have prepared some set of questions that will be answered regarding to our discussion earlier. So for the first question, it will be answered by my partner Sheila Bendecio. Are usual trade exaggerations considered fraud under Article 1340 of the Philippine Civil Code?
No, because according to Article 1340, that exaggeration of seller's stock or dealer stock is not considered fraud, as long as they have an opportunity to check the facts for themselves. Customers should rely on their own independent judgment and don't take those stock literally, as it's risky to rely on its truth. So my questions for you, partner Sherlock. When does inheritance cease to be considered future inheritance?
Inheritance is considered a future as long as the person from the property will be inherited is still alive. Once the decedent or the person from whom the inheritance is expected passes away, the inheritance ceases to be the future and becomes a present right or property of the heir, and also have the purely hereditary right. So inheritance ceases to be the future upon death of the decedent or deceased. So for the next question for you, what does Article 1341 of the Philippine Penal Code say about the difference between an expression of opinion and fraud in contracts?
Thank you for that question, partner. And according to Article 1341, a mere expressions of opinion is not an amount to fraud to a contract, because it is not based on fact but just a mere opinion. However, it is considered fraud if it is made from an expert and the other party relies on the expert opinion to enter into a contract. Then the opinion turns out that it is false or erroneous. And that's next questions for you is, do the person commit fraud if he or she make mistake when he or she sold the jewelry that thought to be real, not knowing that was fake?
No. Since according to Article 1343, misrepresentation made in good faith is not fraudulent, but may constitute error. It could only be considered fraud if the person know that the jewelry was fake, but since he or she doesn't know it, so it's not intentional. It's considered a mere mistake. You can call it fraud if it's more serious than mistake, like he does know it's fake but insisted to solve it.
Yes,
So
okay. Thank you so
that's
much,
all.
partner. So that's all for our Q&A session. And thank you for listening to this module. We hope that you learned something to this module. Yeah. See you next time.
Thank
Bye.
you. Bye bye.